some exciting things are happening with regard to the Second Amendment. I mean, we have a bit of a gun grab bag today because a few things have happened over the past week or so that have been with regard to the Second Amendment and guns more broadly. And there have been a lot of things said, and we begin with a ruling coming out of California that I'm sure all of you have at least heard of by this point. It's something that came out back on Friday about how California's assault weapons ban is in fact unconstitutional, which is of course extremely obvious. Anyone who's read the Second Amendment and doesn't have a ideological point of view stapled to their head that they need to find in it will know that the idea of banning any sort of weapon is somewhat ridiculous. And that is the sort of narrative you'll be getting from most channels with regard to this particular decision. It's a good decision, and for that, the most part, I agree. But I do have a few issues, and all of them stem from one particular thing, which has been, well, a thing since the DC versus Heller decision, which this particular decision quotes from fairly heavily. And that is the common use standard, which is applied to the Second Amendment with regard to what guns can and cannot be banned, and the fundamental problem with that standard as a legal standard, which would be that per the common use standard, would assault weapons, assault rifles, meaning machine guns, select fire rifles, things like the AR-15 or the M16, to be more accurate, assault machine gun, AKs, and that sort of stuff, or just more broadly machine guns, should those be banned under the common use standard? Well, depends on how you interpret the common use standard, because if we interpret it based on the idea of before the regulation is put into place, then the concept of machine guns not being regular usage back in the 30s before they ended up being banned is a bit of an absurdity. They were in fact common use. They weren't uncommon. People were using them all over the place for both legal and illegal purposes, as it turns out. As goes with many weapons nowadays, with the AR-15 and the AK-47 in their civilian semi-auto versions. But the common use standard does not clearly apply to this, because the common use standard generally uses how it is today, how many people use this commonly today as the standard, rather than trying to look back to when the regulation was actually passed for that answer. And this becomes a bit of an issue when it comes to pro-gun activism, advocacy, that sort of thing, because it essentially proofs the NFA and other much older bills from ever being challenged under the common use standard. There needs to be an entirely new standard brought up, one that's more principled and less reliant on temporal context to actually be undertaken. What this standard essentially does, and what I think Scalia was actually thinking when he made up the common use standard, was that he wanted to strike down the DC law without touching the NFA. And the only way he could do that was by, or at least do it in a comprehensive way that wouldn't just apply to the DSC law, but wouldn't, of course, expand its scope all the way to every gun regulation in its entirety, was to create a standard which essentially proofed any law from a substantial amount of time back, since they had been in for so long, most of those weapons had in fact fallen out of common usage. Machine guns aren't commonly used, but I think it would be hard to argue that if they weren't banned, they wouldn't be in common use. What this essentially means is that the common use standard cannot roll back any gun regulations as the unconstitutional things they are. It essentially acts as a stopgap, meaning that nothing new can go forward. California can't ban more guns. The Congress and the Senate can't ban more guns, of course, without changing the Constitution and amending it. The ATF can't ban more guns, so this would probably apply to things like bump stocks or to binary triggers and that sort of stuff. But it also can't roll back any older stuff. It can't roll back the 86 machine gun manufacturer ban. It can't roll back the NFA. It can't do that. And that's my fundamental problem with this whole legal standard of common usage. And this sort of leads into certain other places where we also have some wonderful, wonderful cringe, I would say, from certain people in the anti-gun lobby, because they've changed tack slightly. You see, they've amended the Second Amendment was about a malicious thing and pushed it even further into the Second Amendment was about slave patrols. You see, they have now caught on to the fact that gun control has a very, very racist past, and that most of the early gun control bills and laws in a statewide context had to do with blocking specifically black people from getting firearms. And they've said, well, I don't like that because I'm a leftist and thus a complete idolatrous fanatic for race politics. But at the same time, I don't like guns. So, what are we going to do to fix this? Oh, yeah. We're just going to pretend that the Second Amendment was about slave patrols. Ah, man. And this is amazing. This article from The Guardian, it says, a series of slave results terrified white residents and helped fuel the rationale for gun ownership. Of course, the headline being, America's gun obsession is rooted in slavery, from Carol Anderson. I believe the author of actually a book about this very premise. And it turns out that this entire argument is utterly absurd, because it begins from the perspective of certain aspects of the constitutional debates that were going on. And it brings up an anecdote about the draft of the Constitution having particular strictures in it, saying that the state militias would be trained by the federal government and would be stationed by the federal government. And this was objected to by certain Southern representatives by saying, well, we don't like that because there could be slave results and that could lessen your response time, or raise your response time as it would be. And then she takes this and says, okay, thus the Second Amendment. Problem, of course, being that the Second Amendment didn't have anything to do with this. In fact, the Second Amendment, the reason it exists, is not because of slave patrols, and it didn't have anything to do with the state militias or a federal standing army at all. The federal standing army, or lack thereof, wouldn't be affected by this whatsoever. Hence why we have a federal standing army as it is right now, and we didn't need to amend the Constitution. There's nothing in the Constitution that prevents the federal government from having a standing army. That's why we have one. The Second Amendment, thus, has nothing to do with whether there can be a federal standing army or not, or whether there can be state militias or not. Well, at least partially. You see, this is sort of an extension on the whole past completely ridiculous argument of, well, the Second Amendment is about militias. It's about state militias having the right to bear arms, which is just not true. If you pay attention to the wordage of the Second Amendment, you notice that the militia is mentioned in the first half, what is called the explanatory clause in linguistics, and then in the second half, the militia is nowhere to be found, only the people. Now, in order to make the argument that the right of the people to keep and bear arms refers to the militia and not the people, as explicitly stated in the statement, you have to argue that the Founding Fathers believed that the people of the United States of America were not, in fact, the citizens, or the people who simply lived there, but, in fact, the people of the United States were the people a part of the militia. Or more specifically, in this case, since you're arguing that state militias have something to do with this, that the people in the state militia are the only people who qualify as the people of the United States of America. Now, all of this leads you to one simple conclusion. The people are the ones who have the right to bear arms. And the people implies everyone who lives in the United States of America. Everyone who's a citizen, if you want to be as strict with it as possible. That means that everyone has the right to keep and bear arms. And, of course, it would be an absurdity to limit this arbitrarily. There could be an argument for certain edge cases like weapons of mass destruction, nukes, and whatnot, but we haven't gotten to that point yet, and we're so far away from that point that we don't really need to be worried about legalizing machine guns, for instance. Machine guns aren't really that much more effective than single-fire or semi-auto weapons, especially considering there are so many ways to get around our definition of what a machine gun is, and on top of the fact that you're allowed to manufacture guns in your own home, and if you're willing to bend a few laws, you can create a machine gun at home without the government even knowing you have a firearm. Simply because of how we classify these things, and the fact that, for the most part at least, America's a free country where 3D printers exist. Though I want to be entirely clear, I'm not necessarily condoning these actions or promoting these actions. I'm just saying that they could be done, and not particularly a difficult fashion. The thing is that from this argument of the militia is somehow what the Second Amendment is supposed to be about, and the militia is meaning the state militias, and the state militias, they didn't want them to be trained by the feds, and thus that's why the Second Amendment exists, is all leading up to this idea that gun control in the 18th and 19th century didn't have anything to do with a bunch of tyrants wanting to tyrannize the people. Oh, no. And it has nothing to do, of course, with the gun control advocates of the day. No. In fact, it has to do with the Second Amendment advocates. We're somehow trying to connect Second Amendment advocacy, the advocacy of the right of the people to keep and bear arms, to have firearms, and we're somehow connecting this into gun control advocates in the 18th century didn't want black people to have firearms, thus. To be clear, these laws back in the 18th, 19th century were unconstitutional, but of course they weren't ruled on by the Supreme Court back then for similar reasons as to why the Supreme Court doesn't cover those sorts of cases a lot nowadays. Most of it has to do with, of course, politics, and it goes back to this utterly absurd idea that we can have a non-political branch of government. The fact of the matter is, the judiciary is a political branch of government, because what would it be otherwise? Would it be a private branch of government? What is it supposed to be? I fail to understand how people have such a strange definition of politics in their mind, and really this does extend to a lot of instances, with especially regard with the court, where somehow these people who act in accordance with the public, and they act in accordance with the laws which were ascribed by political actors, and we're trying to interpret these things to a satisfactory way and determine how these things get decided. But somehow, the courts are not political because people don't argue about them? I mean, imagine the utter absurdity of the current definition of politics that most people use. It ends up being essentially an amalgamation of public policy combined with arguments, which is simply absurd. First of all, any public policy can have an argument for and against. It's not as though argumentation is limited in some way, except for by the arbitrary dictates of tyrants. But on top of that, politics and the word public are basically the same word, because fundamentally they have the same root and the same definition. If you're really looking at it from a historical perspective, how the words are actually supposed to be: political health, public health. Those are the same things. Both of them are with regard to the running of the society, of the public. That is political. That is politics. Politics is just the running of society and how that is done. That's all it is, which would, of course, naturally include the justices, would naturally include the courts, because they have a major say in how the society, how the public is run. Of course they're political. Utter absurdity. That's what I gotta say. I kind of went off on a tangent there, but that's where I'm gonna leave you guys off. It's been quite a grab bag week for gun control and gun advocacy and all those sorts of issues. And if you enjoyed that video, do in fact subscribe down below. Look to the links down in the description where I have very many pretty links to other places where I put my stuff and where I'll put my thoughts on occasion. Places like Minds, Gab, and Parler. On top of that, I have breakingonthedaily.locals.com. I suggest you go check that out. If you enjoyed the video especially well, share it. I like to see those numbers, those view counts go up. And that's where I'm going to leave you guys off. I'm KelKidman. This has been Breaking on the Daily. And I'm out.